This is Greenwood's Legal Employment Law Nowcast, episode 13. This is the one about the biggest changes ever. Enjoy the podcast. Hello and welcome to our latest podcast. This one is all about the Employment Rights Bill, which was released yesterday, the 10th of October. We think it contains some really fundamental things, which is why we are recording this podcast very soon after it has been released. As a reminder, this is a bill, so that's a proposal for some new laws that we're expecting in. So none of this is definite yet, but it's a really good idea, an indication of what we can expect. There is also published by the government a document called Next Steps to Make Work Pay, which contains some more detail, which in various situations, which we'll talk about, doesn't currently appear in the draft legislation. So there's a bit of an exercise there in analysing how they all fit together. And in terms of timescales, the government are saying that they will begin consulting about some of this stuff in 2025, and they are expecting the majority of the changes to take effect at some point in 2026. That is with one exception that I will cover a bit later. But that's just a very brief overview of what to expect in this podcast. There's a lot to cover. So I'll hand straight over to John, who is going to talk to us about third-party harassment and sexual harassment and protected disclosures.
Yeah, so the reason why we're tackling this one first is because there's already quite a lot of stuff just about to come in terms of harassment. So people will be familiar possibly with the Worker Protection Act. So that's due to come into force later on this month on the 26th of October. And that brings in some quite significant changes to the duty of employers to prevent sexual harassment. And people may have seen the E13 guidance, which has recently been published. So there's quite a lot of focus on that already. But what the Employment Rights Bill is kind of ramp all that up significantly again. So the first thing that it does is with the Worker Protection Act, in terms of sexual harassment, there was a duty being introduced to take reasonable steps to prevent sexual harassment. Quite a lot of debate in the House of Lords about use of the word all. So in the original version of that, it was a duty to take all reasonable steps, and the word all was removed. Um, However, the Employment Rights Bill now reinserts that word. It also clears up some of the confusion that there's been about whether there is a duty on employers to prevent harassment by third parties, because the Employment Rights Bill includes a specific provision that indicates that an employer must take steps to prevent harassment by third parties. So in other words, not the employer or an employee of the employer. Um, and it then goes on to talk about what those reasonable steps might be and sets out, some of the things it might be. So it could be to do with policies or that kind of thing.
I think it's going to be really interesting to see how this plays out, because I know when I was presenting at one of our Employment Law Now live events a couple of years ago, there was quite a lot of stuff in the press kind of being labelled the banter police are coming to workplaces, and that was all around the inclusion or not of this word all in relation to all reasonable steps. So from what you're saying, it sounds like we're kind of back to that position potentially. So yeah, it'll be interesting to see how that plays out.
Yeah, and I think the other thing is that the technical guidance that the EHRC have published is quite substantial already, and that's obviously based on the duty that the Worker Protection Act is going to come in, which is just reasonable steps. So I think the question is, what more will all reasonable steps actually bring? Um, but it's interesting that there was obviously all this debate about the use of that word all, and it was removed, and now the Employment Rights Bill is going to put it back in, albeit not for a little while yet. I think the other thing to mention in terms of sexual harassment, and this is sexual harassment specifically rather than harassment generally, is that there's a specific provision being inserted by the Employment Rights Bill, which makes sexual harassment a potential protected disclosure. So arguably protected disclosure, so this is whistleblowing, um, it's possible to have read the current whistleblowing legislation to include potentially allegations of sexual harassment, but the Employment Rights Bill puts this in specifically. I think the other key point that is drawn out of that is that it does mean that confidentiality provisions in things like settlement agreements are potentially going to be prohibited in relation to allegations of sexual harassment. So that's the other area that I think changes in relation to this.
Okay, that's really helpful. Thank you, John. Shall we move on to talk about possibly something that has grabbed the most headlines, and it's in relation to unfair dismissal, which Keith's going to cover for us.
Thanks, Michaela. Yeah, as you say, this is probably one of the biggest headline grabbers of the effects of the bill. And it does a couple of things. The first thing that it does do is, and this actually is within the bill itself, it does remove the 2 year requirement of service before someone can bring a claim of unfair dismissal. So the service requirement is completely removed, creating a day one right. That's in the bill itself. The other thing that's in the bill itself is making that clearly a day one right, not a day minus one right. So there's quite detailed provisions preventing people that haven't started employment yet from bringing an unfair dismissal claim. But then moving on to the thing that has got probably most people talking is the introduction of a new concept, which is the initial period of employment. And on the initial period of employment, the bill itself is actually quite light. It's one of these what's called an enabling piece of legislation. So what it does, it gives the power for the Secretary of State to introduce regulations that will explain how this works. But essentially what it does, and what has been covered heavily in the press, is it introduces this initial period of employment, otherwise known as a probationary period, in which period the ability to terminate someone's employment um, is is there, providing you jump through certain hoops. And the difficulty is that those hoops are the thing that are going to be covered by legislation subsequently, which we haven't seen yet. So what we need to do is go back and look at the making work pay and next steps to make work pay documents that the government have produced both before they were elected and since they've been elected. And what we learned from that is that uh, the um, the initial period of employment that's proposed is going to be 9 months. Interestingly, I listened to the business minister on the radio yesterday morning, and he said the way they came upon 9 months as being right is it fitted in with normal practice best. Now, I don't know about John. I know I've discussed this with Michaela. I've never come across a 9 month probation period in practice. 1 month, yes. 3 months, yes. Sometimes 6 months, once a year, but never 9 months. And it feels like that's probably some sort of compromise between the year that many business groups were pushing for and 6 months that the union wanted for. So it looks like they've split the difference and come up with 9 months. But what will be possible in those 9 months, subject to what the actual regulations say, is that provided an employer follows a process, which is yet to be determined what that looks like, it will be possible to terminate someone's employment fairly in those first 9 months if it's to do with something specific to the employee, whether that's to do with their conduct, their ability to do the job, their capability in some other way. What it won't allow you to do is make someone redundant in that time period. That will follow the normal rules of redundancy. So those people that have previously followed a practice of somehow looking at removing the people with less than 2 years service first, and then concentrating on applying selection criteria to people who are left after that process has been done. That won't be possible anymore. It will be a level playing field on redundancies from day one. So, as I said, it's going to be a case of waiting for the draft regulations, which should be out fairly soon. We hope for consultation, and it's worth also mentioning that this is one of those issues that isn't expected to come in until autumn 2026. So there will be some lead-in time for us to get our heads properly around it once we've seen what we have to deal with.
That's great, Keith. Thank you. I'm going to fairly briefly talk about the proposed changes to flexible working now. And we've fairly recently seen some changes to flexible working earlier this year that I'm sure everyone knows about. So employees can now make 2 requests per year, and requests have to be dealt with more quickly by employers. They've now got 2 months to deal with them rather than 3. And the changes that are proposed in this bill build on those changes. So as far as I can see, those things are staying in place. Other things that are staying in place are the 8 reasons that an employer has to potentially decline a request. But there is a subtle change in language in the legislation that we've got at the minute and the proposed bill. So the legislation we've got at the minute is an eligible employee can apply to work flexibly. But the proposed new wording is the employer may refuse an application only if. So, in my mind, and I'm happy to discuss it, but in my mind, that is a bit of a shift to kind of the start point for these kind of requests. And actually, it is, and this I think is linked to the stuff that I've seen in the press about the government's intention that to make flexible working the default. So possibly they're moving more towards employees having kind of the right to work flexibly, and that can only be declined if an employer, and this is another change, reasonably relies on one of the 8 reasons that we've already got.
And
Um,
I agree with you. I think those two things are quite significant changes because I think, as you say, shifting the starting point to they request, but then the employer has to justify why, and also that justification has to be reasonable. I think that's quite a big shift. It will be interesting to see how tribunals interpret that.
Yeah, definitely. It's the reasonableness point for me because that's not a requirement at the moment. Obviously, employers have to go through a reasonable process and tick those boxes in terms of the meetings and the consultation and that kind of thing. But yeah, there will be this real analysis now, it seems, of whether the reason that they are relying on to decline the request is reasonable. I assume in all the circumstances. And it's also quite interesting because for me personally, the work that I've had pass across my desk since the changes earlier this year to flexible working, I have seen an increase in the kind of standalone claim that you can bring if an employer has failed to deal with a flexible working request in the required time. So from my experience, it seems as though it is more of a struggle for employers to deal with the flexible working requests in the now 2-month period. And then these changes will add another layer on top of the reasonableness requirement. So I know we've sat here before and said actually it's the discrimination type claims that we need to be really wary of in relation to these kind of things. And I think that is still the case, but this is not one to be overlooked. Having said that, I haven't seen anything about the compensation level changing if an employer gets this wrong. It's still a maximum of 8 weeks capped pay. So the current weekly pay cap is £700. So that's a maximum compensation at the moment of £5,600. So that's why I say actually I think it's still the discrimination type claims that we need to be wary of in terms of financial compensation. But yeah, this is an interesting change. The other point that I mentioned at the start is that there is an indication in the next steps to make work pay document that this will be a fairly, well, the government have described it as an immediate change, this along with the kind of family-friendly rights, but that's the only indication I've seen. And obviously, if something does come out about this sooner, we will, of course, keep people updated. John is going to talk to us now about fire and rehire and also kind of related changes to collective consultation in redundancy situations.
Yeah, so I think these are really significant changes. So if we deal with the fire and rehire stuff first, so fire and rehire, obviously people will be pretty familiar with it, but for example, you might have a situation where employees in a business have a particular pay structure and you want to introduce something different. You try and consult with them, and if you're not able to reach agreement, one of the ways in which you implement that change is you dismiss those employees and then rehire them under contracts that are exactly the same except they have the new pay structure in. So that's kind of what we're talking about with fire and rehire. And the government has indicated that they would potentially really clamp down on that. Now, we've already had guidance recently which has kind of introduced some further hoops that employers have to jump through in fire and rehire situations. But the Employment Rights Bill goes much, much further than that. So what we now have is a situation where if an employer is thinking of firing and rehiring, um, or firing and replacing. So that situation would be you dismiss the employees on the old pay structure and you hire completely different employees on the new pay structure. So if it's linked to some sort of attempt to vary a contract, either of existing employees or by replacing those employees with new people, then there are now very stringent rules that the employer has to comply with. So they're only going to be able to do that in very limited circumstances. So just bear with me while I just read to you some of the wording and then we'll just sort of unpick it. So the reason for the variation has to be to eliminate, prevent, or significantly reduce or significantly mitigate the effect of financial difficulties, and then there's a few more words, but then it goes on to say, which relate to the employer's ability to carry on the business as a going concern. And the employer couldn't reasonably have avoided the need to make the variation. Now,
That is significant, isn't it?
it's
It's really cutting to the
yeah,
heart of a business and its future viability, I
yeah,
think,
and I
from
think that is really saying, and I think this is probably the way it will be interpreted, if the employer has no other choice, otherwise the business may go under, they can potentially do this. But if it's simply because the business feels that this is the right way to go, that's their strategy, but actually financially it otherwise is fine, fire and rehire will be completely prohibited. I think one of the key things that I think it does throw up is certainly many of the clients that I deal with, they will quite understandably be looking at, for example, changing pay structures or things like that because they're looking ahead. They're thinking, right, these are good changes to make. The business is not in difficulties right now, but obviously you're making proactive changes to try and make sure your business is as healthy and effective as it possibly can. This effectively prevents you from doing that. It's really only when the business is nearly at the wire where you can do these things. The other thing is that there are some very specific provisions about what will be taken into account when deciding whether a fire and rehire process has been dealt with appropriately. And it's all really around consultation. So consultation with a recognised trade union, consultation with elected employees, if there's no recognised trade union. Interestingly, also, there's mention of anything offered by the employer to the employees in relation to the variation. So potentially kind of sweetener payments that might be offered in order to entice employees to accept a variation. But I think it just massively tightens up the whole fire and rehire landscape, and I think it will be really interesting to see how often employers will feel that they can use it at all, and particularly what evidence, what financial evidence will be required from businesses in order to satisfy tribunals that um, that their viability was actually in question. Um, Linked to all of this, not directly, but particularly because we have this reference to consultation with trade unions, is there's another massive change in terms of collective consultation. So, as many of our listeners will be familiar with, when you're proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, there's a duty to collectively consult. And that might be with a recognised trade union, if there is one, if not with elected representatives from the workforce. Now, the key point there is it's at one establishment. And what the Employment Rights Bill does is it removes those words. So previously, businesses who have a number of different divisions or sectors, they might be geographically separate, um, could potentially argue that they could just tot up that 20 in one particular sector or division, and therefore they didn't have to look across the entire business, whereas this now completely removes that. So therefore, an employer who is proposing to dismiss 20 or more employees wherever it is in their business will then trigger the collective consultation requirements. So that actually is massive for larger businesses who operate in that way.
I was chatting to Keith about this yesterday, and my initial reaction was it didn't make a lot of sense because I can see why the establishment kind of concept is in the legislation at the minute. If you're dealing with a nationwide company, for example, and you're proposing to make redundancies kind of in Aberdeen and Essex, and that's currently over the threshold, which would trigger collective consultation if they weren't in separate establishments. To me, it doesn't seem all that relevant.
No,
Though the difference in geography makes all the difference.
no, that's right. You could have two effectively entirely unrelated redundancy proposals, albeit within the same employer. And you've somehow got to try and smash those two groups of individuals together into a collective redundancy consultation where some of the issues are going to be completely irrelevant to one group of employees but very relevant to the other. So yeah, it feels like it's going to be a really problematic one for larger employers.
And I think the other thing to bear in mind is, and this comes back to the point that you made in the introduction about looking between documents to try and sort of work out where this is going. Not in the bill itself, but in the accompanying document, there is reference to a potential commitment to remove the cap on protective awards. So protective awards are the awards that are made if people fail to collectively consult or don't do that properly. So there's a suggestion that there might be even more of an issue for employers in that they might have to, going forward, collectively consult where they otherwise wouldn't have had to. And also, if they get it wrong, there's potentially an uncapped protective award. So it's very significant changes for employers who find themselves in that sort of position.
It's interesting stuff, John, definitely. And just to round off the podcast, Keith's going to talk to us about some other interesting stuff.
Yeah, and we're dealing with these not to minimize their importance, because there's some really important stuff in here, but some of them there's not much to say, and others there's too much to say, and we could sit here for another hour, and I'm not sure that's in any of our interests to do that. So just to pick up on really a kind of follow up on the last thing that John dealt with, there are some pretty major changes to trade union law included in the bill, and there's a lot of it in there. We were expecting it. It reflects the government's commitment to that they've made to the unions. The two big highlights I'll mention, as I say, there's a lot more than this, but the two big highlights is a requirement for employers who aren't unionized to allow access to their workforce from unions. So effectively giving unions the opportunity to come into workplaces effectively on a recruitment drive. So that's going to be significant. You're not going to be able to just shut the door on the unions if they haven't got a foot in already. They're going to have to be allowed in to talk to your workforce. And the second point, and it sounds like quite a small one, but it's really quite significant, is changing the balloting obligations or requirements for industrial action. At the moment, industrial action can only go ahead where a majority of the employees eligible to vote in favour of industrial action. The change that's coming is that it's going to be a majority of the people that actually do vote. So if you've got a small but very vocal group of employees who are pushing for industrial action and they turn out in large numbers to vote, whereas a lot of the workforce are apathetic and don't vote at all, in the old days often that would be enough to prevent the the ballot being successful for industrial action. That's not the case now. In that case, we're much more likely to actually get approval for industrial action through that ballot. Moving on to the next, and this is a really big one in the bill, and there is a lot of detail already there, but there's actually too much detail for us to deal with, and perhaps it's a whole separate podcast at a later date. And that's about 0 hours workers, and this is another of the things that has been quite heavily dealt with through the media. The big headline on this is that people working on 0 hours contracts are going to be entitled to guaranteed hours based on a working pattern. And in the supporting documentation that's been mentioned previously, it looks like the working pattern that you can look back at is a 12-week reference period. So where employees have worked on a 0 hours contract for 12 weeks, they then have the right to be given guaranteed hours going forward based on that reference period. So you can't have a situation so easily where someone is working quite a lot of hours and then they essentially just get cut off. If they can look back at a 12-week reference period and show how many hours they've been working, they have rights to be guaranteed those hours going forward. It's very complicated how that works. There's pages and pages of regulations on how that will actually be addressed. But that's the headline of that. Just a few things, much smaller things to pick up on. Statutory sick pay, that's going to be a day one right. At the moment, the first 3 days of sickness absence can be unpaid, but statutory sick pay is going to be from day one. From now on, once this comes in. On bereavement leave, that is currently limited to parents. The bill proposes removing the word parent from all of the references to bereavement leave, so opening that up to people who meet the criteria but aren't necessarily the parents of the deceased. And the last one I think we'll mention is around maternity protection. So we've had introduced this year the principle that gives stronger protection to people on maternity leave from being made redundant. And two things are changing under the bill. One, it's not just redundancy anymore, so there's a general protection from dismissal during maternity leave and during the protected period, which includes the maternity leave period. So it's widening the protection to all forms of dismissal, not just redundancy, but it's also extending the period for 6 months after the individual returns from maternity leave. Now, there is reference to there being particular circumstances in which you will still be able to dismiss, but a lot of this stuff on the maternity protection is subject to regulations being drafted, so we don't exactly know what special circumstances you could still dismiss someone in. And it's only from the supporting documents, the next steps to making work pay document, that we know that we're talking about the extension being 6 months from the end of the maternity leave period.
Yeah, thanks, Keith. I mean, I think what's really clear from what you've just said is just how much stuff there is, and we're really aware of that, and we're also really aware of how interested people are going to be in all of this. So, as part of our strategy for dealing with this and trying to make sure we keep everybody as informed as possible, we've launched a Just One Thing campaign via LinkedIn, where we're going to be trying to focus on one of these areas in significantly more detail over coming weeks, and we'll try and cover all of the stuff as we go along. So if you're interested in doing that, then please follow me on LinkedIn. You'll be able to see those updates. And I should say that although they'll be in my name, there'll be significant support being given to me in the background by the rest of the team as we try and get to grips with all of these different areas.
That's really helpful. Thank you to both of you. And as John has said, there is a lot to this, but we hope this podcast has been helpful and informative for our initial reaction to a lot of this stuff. And stay tuned for more information as and when we have it.